I call this hearing to order, the Federal Spending Oversight Subcommittee meeting. We're glad that you came. We're a little bit delayed because we got involved with voting, which comes up periodically, and so we got that out of the way, but we're glad you're here. When I think of the federal government, I kind of think of HAL 9000 and the soothing voice. Unfortunately, the soothing voice kind of got out of control, and there weren't any rules, there weren't any regulations on HAL, or the regulations on HAL failed, and HAL got out of control, and there was no turning back. Government's a little bit that way in that it's sort of gotten out of control. There's been a great deal of attention that's been paid to out-of-control government regulations and how they affect the private sector. But today we're going to talk about how the out-of-control, overzealous regulations, how these negative effects affect actually government and actually how they make government more expensive. This happens in many ways, but Congress has and continues to create programs and agencies that promulgate regulations to implement programs. We often give broad definitions of who gets what benefit, leaving it up to the agency to fine-tune the regulation. I've often said when we pass laws, we pass outlines of laws. A good example is Obamacare. It was like 1,500 pages, and there were 1,500 references to the Secretary of Health will at a later date decide this. We really didn't write the law. We wrote a shell of a law, and we gave it to the regulators, and then they write the law. And this is too much power to give to unelected people who aren't responsive to the people. Worse still, Congress, though, gives agencies a blank check on appropriation, saying often such sums as are necessary. We have a bill like that on the floor today on 9/11. They're saying, well, we have to give them more money. We have to give them money through 2092, but we're not sure, so let's just give them as much as they can possibly spend until 2092. The problem is that without congressional involvement, any agency can expand the eligibility for a program and, in effect, increase government spending on their own without a proper appropriation. Similarly, regulations can be used to alter programs and processes to reduce spending, but that doesn't seem to happen very often. A flagrant example of a government agency expanding its mission and spending billions of dollars without congressional approval occurred when the Social Security Administration expanded the disabled population to include those who are obese. Also in the 1970s, disability insurance was extended to those who do not speak English. Really? It's a disability that requires government programs if you fail to speak English? We didn't vote on that. Congress didn't make it a disability. The agency did, and inevitably that added thousands and thousands of people to the disability rolls. Disability now consumes about 17% of the Social Security money. The Social Security Administration's $7 trillion in the hole, but we didn't even decide to make obese people disabled. Some bureaucrat did. Both of these expansions have been curtailed a little bit and rolled back, and I agree with the reforms, but we still should do more. Whatever side you come down on, though, this causes government spending without Congress appropriating the money. Certainly such things were not envisioned when the disability program was created. Administrations publish some of the budgetary impact of regulation, but those are buried deep in the president's budgets, and if we have looked at this, we've found that during the past 3 administrations, Trump, Obama, and Bush, there have been billions of dollars in federal spending changes that have resulted from regulatory changes. I'm told this might not even show the full scope of the regulatory spending. But it's also a question of checks and balances in 2 regards. First, Congress makes laws, and while we generally recognize that the executive will make certain regulations to execute those laws, what constraints exist to prevent regulation above and beyond the intent of Congress? Second, the Constitution reserves the right of appropriation to Congress. I believe we are failing in our duties when we appropriate such sums as are necessary. But Congress does this often. So what kind of checks and balances exist or should exist? This is one of the questions this hearing will address. The Congressional Review Act, which is in itself an insufficient check, does allow Congress to disapprove of significant regulation. However, many regulations fly under Congress's radar and do not get reviewed. I think before this administration, we had actually never, we might have one time before this actually used the Congressional Review Act to reverse regulations. So it's been rarely used, and this administration, only when we got all 3 branches of government were we finally able to repeal some regulations. Previously, divided government had never done so, or government inside of the opposition party. The only other check I know of this is the advise and consent powers over nominees. At a minimum, senators can question and get commitments from would-be regulators as to how they will execute their regulatory authority and hold them accountable. However, recent research indicates that an alarming number of regulations are finalized by career employees that are not confirmed by the Senate. In other words, it appears that unelected career bureaucrats who enjoy civil service protections have the capacity to make what amount to laws and appropriate funds without any real accountability by Congress. That should trouble certainly members of Congress, but more importantly, the Americans they represent. With that, I'd like to recognize the ranking member, Senator Hassan.
Well, thank you, Mr. Chairman, and good afternoon to our witnesses, and thank you. Good afternoon to our witnesses, and thank you for your patience as we went through 3 remarkably slow votes. So I also want to thank the chairman and say how much I appreciate your work, Mr. Chair, and your staff's work on this hearing. And I also want to thank the witnesses for being here today to provide their expertise on these issues. As members of the Federal Spending Oversight Subcommittee, we have an obligation to examine all federal spending in order to ensure that taxpayer dollars are used efficiently and effectively. Today's hearing focuses on how regulations drive federal spending and how accountability within the regulatory process may prevent unnecessary or even wasteful spending. I have long supported eliminating outdated and burdensome regulations that stymie economic growth and innovation, and I'd be glad, Mr. Chair, to work with you on that. At the same time, I also believe that government's first job is to keep the people who we serve safe. Many regulations are intended to protect Americans from harmful products, infectious diseases, and financial exploitation. As we work to both foster innovation and also to protect the American people, today's hearing reminds us that we need to account for the costs of establishing any common-sense safeguards, as well as the costs of failing to provide adequate protections. Keeping track of regulatory-driven spending must involve strong congressional oversight, robust input from non-federal stakeholders, and a thorough judicial review process. I look forward to hearing from our witnesses today about the adequacy of the checks and safeguards that exist to cut unnecessary or unlawful regulatory spending. Most importantly, I hope our witnesses can help us identify ways to continue to improve this process in order to safeguard taxpayer dollars while ensuring basic protections of public safety and the quality of life that Americans hold dear. Thank you again, Mr. Chairman, for holding this hearing, and to the witnesses, thank you for your attendance. I look forward to hearing from you, Mr. Chair.
Thank you. Our first witness is Dr. James Brohl. Dr. Brohl is a senior research fellow with the Mercatus Center. He has authored numerous policy briefs and reports on regulatory issues. His works have appeared in Harvard Journal of Law and Public Policy, the European Journal of Risk Regulation, the Washington Post, among other outlets. Dr. Brohl holds a BA and a master's degree both in economics from City College of New York and a PhD in economics from George Mason University. Dr. Brohl, you are recognized for your opening statement.
Thank you, Chairman Paul, Ranking Member Hassan. It's great to be here with you today. Thank you for allowing me to offer this testimony on the cost of federal regulations as it pertains to the federal government and to taxpayers. My message today is simple. Much of what constitutes federal policy is on autopilot. By this I mean many government programs, including the amount of money spent on them, operate largely outside the annual appropriations process and the active management of legislators in Congress. Now, the true cost of leaving so many important policy decisions on autopilot remains largely unknown, but estimates of automatic mandatory spending and the total cost of federal regulations are in the trillions annually. A simple reform could begin to shed light on some of these costs. Require the Congressional Budget Office to analyze the fiscal effects of regulations. CBO could start with so-called budget regulations, which primarily impact the federal government's budget. Now, as background, in 1969, 29% of federal outlays consisted of mandatory spending, which doesn't require the same active management from legislators because it doesn't typically require an annual appropriation from Congress. By 2018, that number had risen to 61%, so from 29% to 61%. And CPO projects that this will rise to 65% by 2029. In other words, a huge fraction of federal spending is on autopilot, and this trend is getting worse over time. Credible estimates put the annual cost of federal regulation in the trillions. One estimate produced by the Mercatus Center is that the cumulative cost of federal regulation was $4 trillion in 2012 alone. By comparison, total federal outlays in 2018 were around $4.1 trillion. The costs of regulation are an invisible cost that doesn't receive an annual appropriation from Congress. Now, although much of federal spending is not discretionary from the perspective of Congress because it's mandatory, some mandatory spending is discretionary from the perspective of regulators. That's because some appropriations decisions are made by unelected regulators in the executive branch. For example, budget regulations are rules whose primary impact is on the federal government's budget. These rules can come in a variety of forms. They might set physician fees for the Medicare program, consular service fees, or broaden or narrow eligibility standards for agricultural disaster relief, to name just a few examples. The Office of Management and Budget estimates that major budget regulations in fiscal year 2016 imposed a net budgetary cost of about $5 billion that year. That may not sound like much money compared to the massive federal budget, but this cost estimate comes from just 27 regulations. By comparison, roughly 3,000 to 4,000 final regulations are published in the Federal Register each year, so the OMB's cost estimate is very incomplete. Regulations other than budget regulations also impact the federal government's finances, as any regulation that allows or restricts economic activity will have some kind of impact on tax collection. Now, one reason we don't have more information about the budgetary costs of federal regulations is because the quality of the federal agency regulatory analysis tends to be quite poor, especially for budget regulations. Mercatus Center has conducted analysis of the quality of regulatory impact analyses using a regulatory scorecard system, and a key finding from that project was that budget regulations have significantly lower quality analysis than other economically significant regulations. A first step towards addressing these regulatory costs on autopilot is to task an agency like CBO with reviewing the fiscal impacts of regulations. CBO has a few specific advantages that make it well poised to take on this task. First is independence. Unlike regulatory agencies, which are run by political personnel with specific policy agendas they enter office looking to implement, CBO doesn't have an obvious stake in the outcome of regulations. Experience. Since the mid-1970s, CBO has analyzed the fiscal impacts of legislation. It could do the same for regulations, which may be even easier to analyze as they are simpler. Democratic accountability. CBO is part of the legislative branch, which has direct accountability to voters. So to conclude, with more transparency about the budgetary impacts of regulations, the true costs of having so much of the government on autopilot could begin to reveal themselves. Thank you for granting me the opportunity to speak today, and I'm happy to answer any questions you may have.
Thank you, Dr. Pearl. Our next witness is Thomas Berry. Mr. Berry is an attorney in the Pacific Legal Foundation's D.C. Center. Prior to joining the foundation, Mr. Berry was a legal associate in the Cato Institute's Center for Constitutional Study. Mr. Berry is the co-author of the Pacific Legal Foundation's report analyzing the rulemaking process at HHS. Mr. Berry holds a bachelor degree from St. John's College and a JD from Stanford Law School. Mr. Berry, your opening statement.
Thank you, Chairman Paul and Ranking Member Hassan, for inviting me today to testify on rulemaking by unaccountable agency bureaucrats. Today, I'll make 3 points. First, this rulemaking practice has weakened the separation of powers and harmed political accountability. Second, this practice is rampant, including 98% of FDA rules. And third, this rulemaking is unconstitutional. I'll conclude with potential solutions. When senators, like you and your colleagues, question nominees for agency leadership, you're well aware of the rulemaking power that those positions hold. For example, when Robert Califf was questioned at his 2015 confirmation hearing for FDA commissioner, he received several questions on what rulemaking judgments he might make if confirmed. Why then were the vast majority of rulemaking decisions during his tenure made not by Califf, but but by a low-ranking FDA employee who had never been nominated by the President or confirmed by the Senate, an employee who had been hired years before Califf and would stay on well after. In such a system, the decisions this body makes to confirm or reject any nominee simply don't guarantee any effect on the rulemaking judgments made within an agency. Similarly, the President has never nominated, nor is he expected to even know of, these low-ranking career bureaucrats. When rulemaking decisions are made by low-level employees, those rules are deprived of any ability to be traced back to the top, and the people are thus deprived of democratic accountability in those rules. This type of rulemaking has become rampant. The following numbers come from a recent first-of-its-kind study for the Pacific Legal Foundation that I co-authored with Angela C. Erickson. We collected all final rules from the Department of HHS going back to 2001, and the result was that 71% of these rules were signed by non-Senate confirmed employees. That's nearly 2,100 rules. And within FDA, it was 98%. And this is not limited to minor rules like typo fixes. We omitted rules with small changes like technical corrections and found that still 1,300 substantive rules were signed by non-Senate confirmed employees. That's 63%. And looking only at rules deemed significant by the Office of Management and Budget, over 250 such rules signed by non-Senate confirmed employees, or 34%. Those are rules with combined economic effects in the billions of dollars. And now finally, the constitutionality of this. The Supreme Court has explicitly held that the power to issue a final rule is an authority that can only be held by a duly appointed officer of the United States. The Constitution divides officers into two categories, principal and inferior, and the key difference between those two categories is that principal officers must be confirmed by the Senate before taking office, without exception. The Supreme Court has held that to be an inferior officer, your work must be directed and supervised by a Senate-confirmed superior. In the absence of such supervision, Senate confirmation becomes a constitutional requirement. The ability to issue a final rule without the approval of a superior means that such supervision is absent. And contrary to Professor Parker's testimony, the FDA has essentially conceded that for many rules, that supervision is absent. That is why rules can only be issued by officers confirmed by the Senate. Rules issued in any other way are unconstitutional. So the bottom line is this. In just one department, thousands of rules have been issued and continued to be issued by career employees who have no accountability to the Senate or to the people, which subverts the system our framers designed. Now, potential solutions. The simplest would be a short bill requiring that every rule published in the Federal Register must be signed by a Senate-confirmed officer. Short of this sweeping solution, the individual organizational statutes for each department should be amended so that subdelegating rulemaking authority is no longer permissible unless to a Senate-confirmed officer. Congress can further bring attention to this matter through oversight, and hearings such as this can help encourage the executive branch to alter its rulemaking practices. And since subdelegation is always made at the discretion of higher-ranking officers, the Senate can question nominees for agency leadership on this practice and ensure they commit not to subdelegate rulemaking power below the level of Senate-confirmed officers. As the body charged by the framers with vetting the character and judgment of executive branch officers, it's natural that the Senate would take a leading role in reining back this abusive end run around that system. Congress has several options at its disposal to restore the balance our framers designed and ensure that every rule binding on the public is made by a politically accountable officer. Thank you again for allowing me to testify today, and I look forward to your questions.
Thank you, Mr. Berry, for your testimony. Our last witness today is Richard Parker. Professor Parker is a tenured professor at the University of Connecticut Law School. He teaches and writes in the fields of administrative and international environmental law. Mr. Parker serves on the Council of the American Bar Association's Administrative Law Section, where he chairs the Committee on Collaborative Governance and co-chairs the Committee on Environment and Natural Resources. Professor Parker holds a bachelor's degree in Public and International Affairs from Princeton, a JD from Yale, and he received a doctorate of philosophy and politics from Oxford University, which he attended as a Rhodes Scholar. Professor Parker, your opening statement.
Thank you, Mr. Chairman, Ranking Member Hassan, members of the subcommittee. Thank you for your opportunity, for giving me this opportunity to testify today. As an academic, I'm not required to espouse any particular point of view, but my recent research has focused on reviewing the claims of advocates of deregulation like those you've heard from today. And I've reviewed with particular interest the Pacific Legal Foundation report, which I understand inspired this hearing. That report tells a story of unaccountable civil servants imposing exorbitant costs on the public through unconstitutional procedures. For reasons I will explain, I don't share that dark view of how things work in government, and I'd like to explain why not. To begin with, the report cites a recent study by the Mercatus Center, which Mr. Brohl mentioned earlier today, which alleges that federal regulations are costing the federal economy, the U.S. economy, $4 trillion per year. This exorbitant cost is cited as evidence of a regulatory state run amok that needs to be reined in. What you need to understand is that that figure comes from a single unpublished study that derives its estimate not by actually measuring the cost of regulation, but by constructing a hypothetical model of the economy which basically assumes what it ought to prove, that regulations always reduce growth, never promote growth, by, for example, keeping workers healthy, by, for example, avoiding market meltdowns that caused things like the 2008 recession. So obviously, you can prove pretty much anything you want if you construct a hypothetical model that builds your conclusions into the premises of the model. So I suggest we begin by setting that $4 trillion cost estimate to one side. I then want to turn to the claim that the agencies are issuing all manner of unconstitutional rules because, as you've just heard, they appear in the Federal Register over the signature of senior civil servants and not political appointees. This is a very novel and creative argument, but in my judgment, it reads way too much into the name appearing at the end of the rule while ignoring how the administrative process actually works. What I would like to suggest is that what matters to accountability in the rulemaking process is not who signs the rule, but who signs off on the rule and who is accountable for the rule and responsible for that rule before it can be issued. Let's just take as an example the FDA rule to regulate vaping, which the PLF report uses as its prime example. That rule was indeed signed by Leslie Cox, a very senior and very capable civil servant. But what the PLF neglects to mention is that before the rule was issued, it was reviewed multiple times by the Food and Drug Commissioner himself. In fact, I spoke with the FDA commissioner who dealt with this rule, Dr. Robert Califf, by phone the other day, and he told me there were probably a dozen or so meetings in which he personally reviewed the vaping rule or aspects of the vaping rule and grappled with issues surrounding it. He personally signed off on issuing it. The rule then went to the HHS secretary, who also personally reviewed the rule, and he had several meetings on the rule over the course of the rulemaking with the secretary, he tells me. The rule was then approved by the Office of Information and Regulatory Affairs in the White House, which is an OMB office that is again led by an appointed civil servant. Only after clearing these multiple levels of review by political appointees was the rule issued over the signature of Leslie Cox, career civil servant. The point is that at the FDA and across government, civil servants may have their name appear at the end of the rule, but any significant rule goes out if and only if their political overseers review and approve it. These overseers are accountable to Congress, to the president, ultimately to taxpayers. The buck stops with them. The signature appearing at the end of the rule is, in my view, really beside the point. The last thing I want to mention and address is the worry that agency regulations are issuing forth under old delegations of authority that are broadly worded. Is this a bad thing? I don't think so, and let me offer you just a simple example to illustrate what I mean. The Public Health Service Act, first passed in 1944, authorizes the detention and quarantine of, quote, any individual reasonably believed to be infected with a communicable disease in a qualifying stage, end quote. No one had heard of Ebola when this act was passed in 1944, but Ebola came along, and the question is, should the CDC have been required to go back to Congress and get a specific authorization to address Ebola before responding to it? Clearly, no. They did the right thing by using the broad authority delegated to them in real time. The problem is that Congress, that most modern regulations, whether they're of a benefits kind or of a regulatory form, are highly technical and complex, and those circumstances just don't favor congressional micromanagement of rulemaking. Agencies need broad delegation, and Congress does have tools to rein them in through the appropriations process, through the oversight process, and through simple lawmaking, as well as Congressional Review Act if they overstep their mark. I will leave it at that, and I'll be happy to address further questions in the question and answer period if you are so inclined. Thank you.
Great, thanks for your testimony. I think in some ways, you know, whether or not it's a Senate-approved person who signed off on it or a low-level thing isn't as big a problem as that we have to either agree or disagree. Do we have too much of an unelected bureaucracy writing rules? I think our founding fathers never imagined an enormous bureaucracy with millions of people in it. When they talked about the non-delegation doctrine, the idea that you can't give away your powers, even if you want to, Congress is not allowed to, I don't think we adhere to that nearly as strictly as our founding fathers intended us to. And I think it's kind of hard to make the argument that there isn't an overzealous nature to regulation when they're, you know, telling us how many cherries need to be in a cherry pie. And I just kind of think probably no one's going to be losing their life whether there's 42 cherries or 41 cherries. And probably we could list 10,000 examples like that, you know, as you look through government. So I think there is a problem when the pendulum's gone way too far. I'd love to go all the way back to where government was intended, but may not get there. But for certain, I think part of the hearing, and I think what should come forward here, is that the pendulum swung way too far in the direction of having unelected people make these decisions, often making decisions that could lead to $100 million worth of costs, major regulations for the economy, but not only for the economy, for the government. I'm not so sure I agree with if we confirmed everybody. I've been here. It's hard to get to know all the nominees. It's hard enough just confirming the ones we confirmed to get validity to what the people are actually telling you. Most time you ask them to make a judgment if they want to be head of the FDA, and they'll say, well, I can't comment on anything that's going to come before my committee. Same way Supreme Court works. So it's very difficult. But what I would say is that the one thing that tends to work when you have people on both sides of things that tends to find justice is when you have advocates in the judicial system. There's an attorney for the defense, an attorney for the state and the prosecution, and they battle, and we get a version of the truth by what comes forward. And so one of the things I think would actually work is if we actually had a taxpayer advocate involved with regulation, or if we talked about the mandate. So for example, we have the Fed has a mandate, you know, for price stability and employment. People always debate, well, what if we change their mandate? What if we change the mandate for regulators that it's not just to regulate, but it's to regulate, and how we talked about some of these other ideas, that the cost would have to be part of it. I don't know if that's even part of their mandate. I can tell you as a physician that over a 20-year career, day after day, year after year, there's always new regulations added. I can't point to almost any of them that help with quality. Almost all of them are pushing paper. In fact, I think there's so much paper to push that it might distract you from actually missing something that you shouldn't miss because you're not paying attention to the patient. Never does the Joint Hospital Association come and say, you know what? We've gone too far, and this year we're going to take away a regulation. And so this is the nature of the beast. Government gets bigger and bigger and bigger because nobody ever takes away from it. So I've been an advocate, and we've put this forward. I think Senator Johnson and other people have put it forward. Repeal 2 for every 1 you add. Just force people to look, and people say, oh, that would be terrible. It'd be so indiscriminate. You'd get rid of something that's going to save people's lives. We've got hundreds of thousands of regulations. We've got stupid ones like how many cherries are in the cherry pie. For goodness sakes, let's review all of these things. But I think the idea that we're too stupid to be involved with regulations and that the scientists and the regulators know better than us, they're not responsive to people, and they hear one side. And so I think it's a one-sided debate. So I think we really do need a taxpayer advocate. The same goes for all of these things. The National Science Foundation, we print something probably once a week on, you know, crazy research. You know, are Japanese quail more sexually promiscuous on cocaine? Are people more or less likely to eat food if the person in front of them in the cafeteria line sneezes on the food? $2 million from NIH. The one for the Japanese quail, $300,000. And people say, well, Congress, you're not smart enough to decide who gets grant. I think actually the opposite. What I would do for all the grant process for scientists is if it's behavioral science, I'd make sure that every committee has someone representing the diabetes community of science, the cardiothoracic, the Alzheimer's, the cancer. I'd have all of those on every committee, and I'd have a taxpayer advocate. Right now, if you want a behavioral science, which is where a lot of the crummy research comes from, the people reviewing it are the people who will then review you know, they review you, you review them the next time. It's a small group of people all in the same field, and the taxpayers never represented. That's the way I feel for regulations as well. Maybe if we had an adversarial thing where there was an advocate for the marketplace, an advocate for, you know, arguing what is the cost of this regulation, should we do it? But, Mr. Berry, what do you think of that idea? Not saying I would vote against confirming more people. I'm just not sure it gets to the point. But whether or not we actually got someone into the process who is an advocate, or maybe change the mandate of what we tell regulators to do.
That seems like a very promising idea to me. It's sort of the first time I've heard of something like that. But I think the key point is that, as you said, the legislative branch is not under-equipped to sort of deal with these issues of a lack of expertise that a lot of people often bring up. I think in many cases those blur the lines between advice and help in drafting versus final decision-making. And the system that was set up is that 535, yes, generalists in the legislature who are not necessarily experts on quail or anything like this would take in advice from many sides, including, I think it's a great idea to take in advice from a taxpayer advocate, and would synthesize those and ultimately come to a decision that synthesizes those. And I'd analogize it to Senate-confirmed judges who are generalists, who are not experts in necessarily the medical issues that come before them in malpractice cases, but who we rely on to make the final decision based on the credibility of the experts that come before them. So I want to emphasize that our proposal, and I think your proposal also, doesn't say no expert, we should kick all the experts out of Washington. It simply says we shouldn't allow them to have final decision-making authority that doesn't end run around the only people who are politically accountable.
Yeah, and you could even call the advocate that judges on grants or something to be a lay scientific graduate, someone with a science degree that comes from a lay perspective as a generalizing. But we've got to have more, because this stuff's been going on since the time of Proxmire. I mean, everybody he complained about waste. The same, there was a study of $50,000 trying to study what makes people happy, and he made such fun of it in 1972. Still going on. None of that has improved an iota since 1972. And it's really because we give them more money, and they won't ever conserve their money or spend it more wisely until they have less of it. Dr. Brohl, do you want to comment on the thoughts of either a taxpayer advocate or a lay advocate? And also, do you think it's enough? You talked about having some reporting requirements, which I think might help, but I just wonder if it's enough to actually transform the situation.
So when the Administrative Procedure Act was passed in 1946, it actually created two procedures for creating regulations. One is the way that we're used to, notice and comment rulemaking. Agencies propose a rule, take comments from the public, finalize them. Another is called formal rulemaking, which is actually not used very often, but could be used. And it would establish trial-like procedures for regulations, where an agency would have to present its case, provide evidence, provide witnesses. Those witnesses could be cross-examined, and someone like a taxpayer advocate.
You're saying some of that exists already?
It's part of the Administrative Procedure Act. It's called formal rulemaking. It's just that
And
it's
is it ever
rarely
used in that fashion?
What's that?
Is it ever used in that fashion?
There are some specific agencies, like EPA and OSHA, that can use it in some cases, but as a general matter, it's not used very often. Sometimes,
And this is, I guess, my point is that you get one side. The people appointed and who want to become regulators want to regulate.
Right.
They don't become a regulator because they think, well, the marketplace would handle this better. They already have the predisposition to thinking regulations work. So maybe if you had more of an adversarial process, you'd get market advocates saying, well, yeah, it may work, but you may no longer have an industry, and talk about the ramifications of something in advance. And it's how you find truth. How do we find truth? I've got facts on my side. Senator Hassan's going to have facts and an opinion on her side. How do we find truth? By discussing it and then finally letting somebody vote on it. But no, that's good. Did you have a further point you want to make?
I would just say anyone who's submitted a comment to an agency as part of the notice and comment process knows it's very easy for them to dismiss you if they want to. As a general rule, it seems like they've made up their minds often before they've even proposed a regulation. So it's very hard to see regulations changed. It's hard for just a member of the general public to make a difference.
Right.
But if there was more of an adversarial process, that could make it more possible.
Senator Hassan?
Well, thank you. And thank you. And I see that Mr. Parker would like to respond to a couple of these things, but if I can ask a couple of questions first, Mr. Parker, and then I think we'll have the opportunity for discussion. And I do want to just kind of point out that there is significant regulatory process that some might argue is significantly more transparent than the process Congress uses to make laws. And there are comments that come in on regulations supporting, for instance, net neutrality, but Congress went ahead and overruled those comments and withdrew the net neutrality regulation. So I'm not sure that all of the problems here rest with the regulatory process. But I want to just start with a couple of questions to Mr. Parker, because I believe sometimes it is necessary and appropriate for agencies to update their rules to reflect new information or other changes that come to light from the outside world. Mr. Parker, could you provide an example? You talked about Ebola, but of how agencies have updated their rules within their existing statutory authority to address current issues that have emerged.
Sure. I think if you go through the Code of Federal Regulations, you'll find that the vast majority of rules that are issued are either very minor rules, like rules having to do with the opening and closing of the quail season or drawbridge times, or else they are revisions to prior rules. They are updated all the time. They're modified all the time. It's very cumbersome to modify them, actually, because of the notice and comment rulemaking process and the analytical requirements that have been imposed on it. You know, whether it's emission standards for vinyl chloride or whether it's eligibility standards for a benefits program, you'll find that rules modify rules all the time. The only way that any rule can be modified is by issuing another rule. People need to understand that. So when you talk about 3,000, 4,000 rules issued a day, many of them, a year, many of them are rules that just change other rules and make them better in response to comment from the public and problems raised by the public.
Okay, that is helpful. Following that point, I think it's important to acknowledge that agencies do work that Congress cannot, namely crafting policies with a level of expertise that's outside the scope of what we do on the Hill and reacting to emerging threats to health and safety. In many circumstances, the benefits of regulations outweigh the costs. Can you just give us an example or two? You started to on the benefits, Mr. Parker, of agency rulemaking to the American people.
Well, I think to understand the benefits of rulemaking to the American people, you have to go back to what the world looked like and what the United States looked like before the expansion of the administrative state really began in earnest. President Trump made news by saying he wanted to return the Code of Federal Regulations to the size that it was in 1960, when it was about 1/10 the size that it is now. Well, in 1960, EPA did not exist. Occupational Safety and Health Administration did not exist. You know, the air was so filthy that killer smogs were killing people, you know, in a matter of days and weeks, not even in a matter of months and years. Lake Cuyahoga caught on fire, right? So regulations have had a huge impact in promoting health, safety, and protecting the environment. Yes, they are complex, but they have accomplished an awful lot. And let me just say that there is a tendency to think of agencies as the sort of the father knows best or mother knows best, the know-it-alls, the experts. In my experience working with agencies, and in my consulting capacity, I've actually led rulemaking exercises for agencies, negotiated rulemaking exercises. What I have found is that agencies don't have the expertise to make good rules in these complex areas like vinyl chloride standards or auto safety standards. They rely on industry and they work collaboratively with industry to get the information that they need. Industry is very much consulted throughout the rulemaking process, and it's just not true that industry and the regulated community have no say in how the rule reads. In fact, what I teach in administrative law is case after case where the agency ignored an agency comment and then was reversed for failing to do that. One classic example is a case involving the regulation of smoked whitefish, the Nova Scotia case, where an agency, you know, did issue a bad rule. They didn't take into account of the industry comments, and when the case came to court, the court said, you didn't respond to the comments. You didn't listen to this industry. This rule is arbitrary and capricious, and the court throws it out.
Okay.
Agencies worry about that, and as a result, they do listen, and that's one of the things that makes them, we always say that agencies are not accountable, and Congress is, but this fear of judicial review, this fear of judicial oversight, is a real check on agency powers that forces them to listen to industry when they speak and to stakeholders when they speak.
Well, okay, thank you for that as well. And I wanted to touch on one more thing before my time comes up, and then we can move back to the chair. I think we should also acknowledge Congress's role in holding agencies accountable to the statutes we enact, and we have several ways of doing that. With that in mind, I'd like to turn Mr. Parker to the Pacific Legal Foundation's article on the role of career civil servants at the Food and Drug Administration in the rulemaking process. I have profound respect for federal employees and the work that they do, but I agree that it is imperative that we have accountability in the rulemaking process, and you just talked about the judicial oversight providing part of that. What role would a career civil servant, rather than a political appointee, serve in that process? Why might a career civil servant's name ultimately end up on the final rule?
Yeah, that's a great question, and I actually asked that question of Commissioner Califf when I talked to him on the phone, and he said, well, there's a sort of tradition of putting the name at the bottom. I think it's a way of just sort of, I think of it as something like the person who packs the parachute has to jump their own parachute every so often. It's a way of saying this is the person who was responsible for coordinating this rule and for putting it together. It's the Associate Commissioner for Policy. That's been the tradition. It's a way of sort of honoring them, recognizing them, holding them accountable. But it's not to say, and I don't think it is meant to say, that it is their authority which authorizes the rule. It is not to say that they were solely responsible for issuing that rule. This is an FDA rule that goes out, and it has to be reviewed and approved by the FDA. And the FDA, political appointees, and the FDA itself is responsible for every single rule that they issue.
Okay, thank you very much, Mr. Chair.
I agree with Senator Hassan that a lot of the problem, there is congressional responsibility that we've abdicated, so ultimately it is our fault. We don't do our job, and particularly with writing legislation. The legislation is very, very loose, and then people are surprised. Oh my goodness, they're doing this, and we had no idea that we even gave them power to do this. And it happens not just in sort of environmental regulations, it happens in regulations of your privacy as well. So for example, when the Patriot Act passed, James Sensenbrenner in the House was a big advocate for it and one of the authors of it, and pretty much thought it was a good thing. And then when all of a sudden Snowden revealed that billions of people were having their phone calls recorded by the government under the pretense of that, he says, no, that's not what we intended at all. And not only that, the intelligence community at that time really closes ranks, and really probably even bigger and worse than all of the sort of the business or environmental regulations are the things that happen in our intelligence community that no rank and file senator is ever told about. And I think there's a great abuse of congressional authority. But once again, we could write stricter rules and we could do it. But in the end, what happens and what comes forward is congressmen are lazy and they say, oh, it's to fight terrorism, so you don't care about civil liberties, we're going to fight terrorism. So everything just flows on and it gets worse and worse. Examples of how people get kind of crazy crossways with regulations. There was another one in our state. We had a lake where the earthen dam was possibly going to fail, so we decided to repair it, and they dropped the lake by 40 feet. So some enterprising environmentalists went into the area where the lake was lowered, and lo and behold, they found some dusky darters there. And they then hypothesized that if we put the lake water back in the lake, we might hurt the dusky darter. Well, the government created the lakes, and we had a big fight over the government taking property in the 1930s, but we kind of decided that one, it's over. We got a lake. Now we got these marinas, and the environmentalists are saying, oh, you can't fill up back the lake because you might hurt the dusky darter, to which I responded was, well, don't they live in water? Won't they like more water? But you can see the craziness that you can kind of get into on some of this stuff. Unfortunately, their saner heads did prevail, but we have a lot of stuff like that. I'll give you another example from endangered species. We have the pocketbook mussel that's supposedly endangered, and people say, well, you are just a senator and you know nothing of science and you should not get involved with this at all. Well, they studied the population of it probably, 30 years ago in about 5 places and said, oh, there's a shortage of them, where they're endangered. Well, since that time, there have been 20 more studies, and everywhere you look, you find one of these things. They're everywhere. If you've ever seen mussels propagate, I've got a pond behind my house. You can't stop mussels. They come in on the birds. They come in from everywhere. There are mussels everywhere. There's no shortage of this mussel. It's been found in 30 other places. We can't get it off the endangered species list because really those people don't work for us. They're sort of in charge of it, or we just abdicate and we fail to tell them it's time to take the pocketbook mussel off. But it's a big racket too. So what happens is anytime you want to build something in any state that has supposedly the pocketbook mussel, you got to get a consultant. It's almost always approved, but it costs you $100,000 for the consultant. It's a huge racket. They're all in league with this, and they love the consultants love the regulators because they have a whole racket going on this. We have archaeology consultants and pocketbook mussel consultants. They always have to be paid. Another example of how you pay the regulators. Bats. We say that the Indiana bat there's a shortage of Indiana bats. They're rare or whatever. It's really hard, even for scientists, to tell the difference between that and the brown bat, which there are a gazillion brown bats. They say you can't cut down your tree. Oh, no, you can cut down your trees if you pay us. And it's like, really? If cutting down the trees is going to hurt the bat, why would you just say we can't cut them down? You just have to pay the government money. So it isn't really about the bat, it's about exchanging money. But this goes throughout government. I mean, we could spend days and days and days of talking about regulations that have run amok, but we really have to figure out the conclusion of where we are on the spectrum of belief of whether government's too big or too small. And I don't think it's zero government versus totalitarianism, but I would say that the pendulum has been gradually growing and growing and growing for more unelected rules and laws, and we do need to do something about it. I like the idea of looking at the regulatory mission, cost, mandating cost analysis, maybe confirming more of the regulators. I'm not sure if it'll work or not. But I really like the idea of maybe utilizing some of the trial process that we have and see if there's a way to do that and bring in the adversarial nature to it. Some of that would probably just take an executive who chooses to police the executive branch that way. But any other suggestions on the idea of trial process, or does anybody know anything more about how we actually do use a trial process? Any of you? Mr. Parker, Professor Parker.
Go ahead.
Yes, administrative lawyers are familiar with a time when formal rulemaking was actually used and tried. There's a famous story about how it took 12 years to figure out how to label peanut butter using formal rulemaking.
My guess is the marketplace figured it out before that.
The problem with trial-type procedures applied, and I'm going to take issue with your idea, but I'm going to offer a constructive alternative, which is of a similar nature. The problem with formal rulemaking applied to, trial-type procedures applied to rulemaking is that there are many different actors. There are many different industry positions in any given rule. There are many different ways of doing things, many different production processes that produce different kinds of pollution, et cetera. In my work at convening negotiated rulemaking exercises, I've discovered that industry is not just one thing. There are many different actors in the regulated community, many different beneficiaries as well. You can't have everybody cross-examining everybody else. You can't have everybody, it's not like a trial, it just doesn't work that way. This is a polycentric exercise. The idea of a rule is it's of general applicability and future effect. So how do you get this? But you're right that these folks need to be consulted. They need to be consulted for their expertise, and they need to be consulted for the legitimacy of the process. One way that I think could capture a lot of what you're trying to do is greater use of negotiated rulemaking, which I have personal experience with. Full disclosure, I've been paid for doing it, so I like it. But I'm not pushing for me to do this. I'm saying this is a process that really works. What negotiated rulemaking does is it's another way of coming up with a proposed rule or a revision to a rule, but it requires that the industry be at the table. It requires that the public interest community be at the table and that regulators be at the table. It's presided over by a neutral facilitator or convener, which is what I did. But everybody is heard, and it's a magnificent BS detector, right? Because if you say something that's wrong, you will be called out by other experts and other stakeholders around the table right then and there.
No, I think it does.
So that might be something that you could explore and that would be doable.
No, and we're open to that, and we will look at that. I think that the other thing that has to come into this is every regulation can be looked at through either an adversarial process or even this kind of process. But we set dollar limits or whatever, and we figure out, and certain of them will be, and the more important ones absolutely should be. But you mentioned industry a couple of times, and I think it's important from the understanding that I don't consider myself to be an advocate of any industry or for industry in general. I'm an advocate for capitalism in the marketplace, for people mostly being left alone if they don't hurt others. So what I would say is my experience up here has found that most industry loves regulation. Big banks love all the regulation, all the compliance, because there's a compliance cost. They can absorb the compliance cost, and the new guys can't. Small banks don't like the regulations. Big banks don't care. They've already hired it. They've baked it into the pie. And so often you get that. The other thing that's particularly infuriating to me is the businesses coming up here all the time saying, we hate California's regulations, please regulate us nationally. So every business group comes to me and wants to be regulated now, and I say, beware. You don't know who the next president's going to be. You don't know who the next Congress will be. And then with the flip of the switch, the national rule will become California's rule. But it's all this getting away from there being, places where you can seek refuge, the states to seek refuge from the federal government. And I think that's a big mistake. Dr. Brohl, do you have any comment on industry, business actually promoting or actually liking regulation to keep out competition?
Absolutely. I mean, there's a well-known phenomenon in the economic literature known as regulatory capture, which is the idea that regulatory agencies tend to get captured by the industries they regulate and serve their interests. And when I made that comment earlier about being ignored in the public commenting process, I wasn't referring to industry. I was referring to members of the ordinary public who really have trouble making a difference. And the reason is very often because regulatory agencies have sat down with industry before they've even proposed a regulation, hashed out some kind of deal or arrangement with them, and then it's only at that point that they propose a regulation and the public has an opportunity to chime in.
And I think it's hard because people don't look forward to the unintended consequences of it. So right now, everybody's up in a roar about surprise billing in medicine. So we're going to regulate what people can charge, and they have to accept a certain rate. 5 years from now, we're going to come back and say, oh my God, I can't believe we did this. We've now regulated maybe 75% of the medical transactions because it's going to be everyone associated with a hospital. Over half the doctors are associated with hospitals now, so it's not just going to be ER doctors, it's going to be doctors, and then as that increases, it's going to be every transaction, and then we're going to find out that we have shortages because people are going to say, I'm not even in the network, why should I offer a discount? Now I got to take the discount, and all of the power will devolve to the insurance companies, and all the complaints we have about big insurance are going to be worse, but nobody realizes that because nobody's thinking through the end result of that.
And actually, I'll just say that I think we are trying to address that very issue in the version of the surprise medical billing because there's been a good back and forth. So, I don't want to turn this into a help hearing, but I do want you to know that that's being hashed out.
Let's hope, because it's sort of the inadvertent result is that people say, well, insurance companies are getting too big, tech is getting too big, and then we attempt to regulate it, but we make it worse. Doctors are small potatoes in this. Hospitals are fairly small potatoes compared to the insurance companies. So when we do something that the insurance companies all love, we should be a little bit wary that but we're also getting involved in the marketplace. We are going to dictate what the rates are for medicine and who can join, who can't join networks. And the thing that isn't really discussed is some doctors want to be in the network and are excluded for it because it's a monetary thing. And then some doctors say, well, they're only offering me $50. Why should I be in the network? And so they don't take the $50. And guess what? They promote, and then now they're going to say, well, you got to take the $50. So you're stuck. You don't get in the network, and you're going to be stuck with the $50. And it's like, if you were in the trucking business or selling carpet or pens or glasses, would you want the government to tell you how much you sell things? I think it's a terrible disaster that's going to unfold from all of this.
Well, again, not wanting to turn this into a health education, labor, and pensions hearing, which Senator Paul and I both serve on, I am going to have to go in a minute, so I just wanted to thank all of you very much for your testimony, for your attention to this. I would look forward to continuing this discussion, both with the chairman and with all of you, because I actually thought I heard some levels of agreement among the three of you, including, that there's a role of judicial oversight that is important here. There is a role, obviously, of congressional oversight, but there's also some really good ideas and some really, I think, joint and common concerns about how we make sure that members of the public actually really have a voice in the regulatory process, something hard to do in a capitalist democracy, but we're a capitalist democracy, so that's where regular people are supposed to come in, and it's a reminder to members of Congress that we are supposed to be taxpayer advocates too. So I would look forward to that continued discussion. I'm sorry I have to go to another meeting, but thank you all for very illuminating testimony and for your fine work.
Thank you, Senator Hassan, and we'll keep working with your office to try to find common ground, to find reform type of legislation that we can sign on to from some of these ideas, and I know our staffs are continuing to talk. At this point, being the libertarian that I am, I'm going to say, is there anything else you want to say? But you got to keep it under about 2 minutes or so apiece. Mr. Berry.
Sure, thank you. I just wanted to briefly comment on what Professor Parker brought up about Commissioner Califf's claim that these procedures really, they always go up to the top and that the name on the brief doesn't matter so much. The FDA in litigation against the deeming rule, where I represent some clients who sued against it, and conceded that the Associate Commissioner for Policy was the one who issued the rule, and they conceded that it was under her rulemaking authority that had been subdelegated by the FDA Commissioner. And when they attempted, and so the entire crux of the case is not whether she issued the rule, they admit she did, it's whether she was validly appointed as an inferior officer and whether inferior officers in her case can constitutionally issue rules. And the second interesting thing is that they cited every statute they could for supervision, but they didn't have one that essentially showed that the FDA commissioner has to sign off on these rules. They had one that said the FDA commissioner can also issue rules, but that's sort of obvious. They have concurrent authority. And the only oversight they cited was one that said highly significant public policy question rules can be reviewed by the HHS secretary, but presumably don't have to. And given that only about 2% of FDA rules have the signature of the FDA commissioner or HHS secretary, it seems like that's a pretty small number of them. And given also what we've said about political accountability and how people want to know that their comments are at least being heard by someone, I don't think it's just a formality whose name appears on the rules. I think that's what people, the general public, is going to look at. And when these things are done behind the scenes, you kind of, higher-ups can play it both ways. If a rule becomes popular, they can say, oh yeah, I was very closely involved in that. And if it's not popular, they can say, my name's not on it.
Anybody else? Professor Parker?
I'll just say that when the public or a member of the public sues to challenge a rule for being arbitrary and capricious or a violation of law, the lawsuit doesn't read so-and-so versus Leslie Cox. The law reads so-and-so versus the FDA or the FDA commissioner, right? The lawsuit, it is the commissioner who's ultimately responsible. And
May have to do with sovereign law or something where you have to sue the government or not.
And I don't know, but the agency is ultimately responsible in court and to you, accountable to you for every rule that goes out over the FDA's signature, right? And I don't think anybody has ever come to you and said, well, I don't know about that rule. Leslie Cox issued that rule. I don't, I don't defend that rule.
I think the bigger question is not really actually on who individually it is, whether it's higher up or the middle management or the lower management. It's a little disconcerting if it's a huge rule and lower management is doing the rule. But I think the bigger concern is, are we involved with too many rules in our world or too few? And I think that if you look, I just find it hard to believe that the evidence isn't overwhelming that our government's gotten too big and too involved. And like I say, there's lists of thousands of ridiculous things, like how many cherries in a cherry pie, how many apples in an apple pie, that really, we finally got somebody, the current administration got rid of some of that stuff and threw it out. but those things have been on the books for decades and decades and decades. So I think we do have to consider whether we do too many things or too few things, and I don't think anybody's arguing for no regulations, really. I mean, we're arguing for whether you want more or less. And it's sort of the argument we have here in government for taxes. Do you want more or less? Nobody's arguing for zero. Nobody's arguing for 100%. But with corporate taxes, it's very clear there's a division between the parties. One party wanted to keep a 35% corporate rate, and the other party wanted a 21%. It was a clear demarcation, more versus less.
I would just say one thing, that you're absolutely right that the Founding Fathers did not contemplate the growth of the modern administrative
We
state.
can definitely agree on
We
that.
can agree on that. They also did not contemplate modern aviation or modern cars or the explosion of the proliferation of toxic chemicals, none of which existed. These are all man-made chemicals, none of which existed in their day. So
I would probably take a argument with that in the sense that they did have significant pollution back then. They had airborne things, probably in many ways more than we have now. The air of London was worse in the time of our Founding Fathers than it is today. And this is a lot of things that people don't really realize about the environment. The EPA has published that of the 6 main pollutants in our environment, they've been reduced by 70% over the last 40 or 50 years. But the real bad pollution that we had in our history was when everybody burned their own fossil
Yes.
fuel in their fireplace. And so by concentrating at utilities, actually the air is much cleaner than it actually used to be. Dr. Brohl, a final comment?
I would just add that I think the idea of pursuing more negotiated rulemaking sounds like an interesting idea. I believe that formal rulemaking can work and has worked in the past. Some critics have said it takes too long, but I think that the evidence is
That sounds like to me an advantage, that it might take a long time to get a new regulation.
Well, it's also just not true. For example, the peanut regulation, it wasn't formal rulemaking that dragged that process on and on for years. It was other factors. It just happened that that rule also went through formal rulemaking. But I'm also serving on a negotiated rulemaking right now for the Department of Energy, and I'm the consumer representative on this working group. And it's an interesting experience. Wouldn't say it works perfectly. It would be nice if there were more people like me on that working group, because I'm essentially, there's lots of representatives for industry, there's lots of representatives for the energy efficiency activists, but there aren't really more representatives for just the people. So if you had a taxpayer representative or more consumer representatives that could balance that out, I think that would be a good thing.
I think that's a good idea. We'll send you a summary of what we think are some of the ideas we've discussed. Feel free to comment back to us. If you have ideas in general in the future, always feel free to communicate with us, because we do consider you to be experts on various sides of the issue, and we'd like to hear from you. But thank you all for coming. Meeting adjourned.